So it's been really fascinating for me because most of my research to date has focused on sort of issues relating to beginning of life, you could say. So abortion, access to fertility treatment, involuntary sterilisation, surrogacy. They've been sort of my main focus. As part of the abortion research that I've done a lot of work looking into conscientious objection to abortion. And so that made me start thinking about whether there are other areas of medicine where there's sort of a strong cohort, I suppose, of health professionals that have a conscientious objection. And really, voluntary assisted dying is kind of the main one aside from abortion. So that's what originally got me interested in looking into it. It seems that beginning and end of life issues seem to be the most, the areas where people feel most emotional is what I would say. Look, I think it's obviously an area that's in need of research at the moment because it's so new in Australia. So, Victoria really took the lead in legalising voluntary assisted dying back in 2017. And when you think about it, 2017 isn't that long ago, right? It's only like 5 years ago. So, unlike abortion, which has been around for a really long time, voluntary assisted dying is kind of still in its infancy, and I think there's going to be numerous iterations of the law, probably in all the states, as we realise where the gaps are and where some of the problems are and where there may be need for improvement. So I'm hoping that this research will, shine a light on this specific issue of conscientious objection, and will help people to understand, first of all, what the actual impact of conscientious objection is. So whether it is, in fact, impacting on people's ability to access voluntary assisted dying or not, because that's a real practical question, which then should feed into what the shape of the law looks like, but also to understand some of the reasons behind people's conscientious objections, because this can also help us understand what the best way may be to accommodate both the values of doctors with a conscientious objection, as well as people's legal right to access voluntary assisted dying. So, for example, a number of palliative care doctors that I spoke to expressed the view that they personally were not comfortable being involved in the process of voluntary assisted dying, and they didn't feel that it should form a part of palliative care, but they recognised that there was a role for it more broadly. And so understanding that can help us understand perhaps how voluntary assisted dying should fit within sort of this overall construct of care being provided to people experiencing serious medical conditions. In the abortion context, most conscientious objection comes from a religious place. People believing for religious reasons that, the fetus is a human life and shouldn't be killed. That's sort of generally the basis for conscientious objection to abortion. And I went into this research on voluntary assisted dying assuming something similar. So assuming that most health professionals with a conscientious objection would object for religious reasons, on the basis that, for religious reasons it's immoral to take a life, that sort of reasoning. But actually, I found that in the interviews that I've conducted so far, most health professionals that object to voluntary assisted dying religious motivations aren't their primary motivation, is what I would say, or their primary reason for objecting. For most of them, it seems to be based more on what they feel their role is as a doctor, and their obligations under the Hippocratic Oath to do no harm. So in that sense, it is quite different to the abortion context, because in many ways, what I've found is that both health professionals who are supportive of voluntary assisted dying and health professionals who are opposed to it have, in a way, the same objective, which is, relieving patient suffering. They care about their patients, but they interpret their obligations as health professionals somewhat differently. I think there is some basis to the perspective that that objection comes from a religious place, because in practical terms, a lot of the health facilities which won't allow voluntary assisted dying to take place on their premises are faith-based health facilities. So there's clearly a religious link in that sense. But I suppose the point is more that it's about more than religion. It's not only about religion, but certainly for many people there's a religious element, and in the way that the law operates in practice, religious values do impact upon people's ability to access voluntary assisted dying, depending on where they may be. The obligation to refer was really first talked about in the abortion context when states began decriminalising, really sort of beginning with Victoria in 2008. And what most of the Victorian states have done in relation to their abortion laws is to say that while conscientious objection is still permissible, if a doctor has a conscientious objection to abortion, they have to refer the woman to someone without a conscientious objection. So that's not like a medical referral, but it's more that they have to direct the woman to someone without a conscientious objection in order to ensure continuity of health care, that she can still access the care that she requires. In the voluntary assisted dying context, it's quite interesting because in some ways one may have expected that the states would just follow that same pattern that they implemented in relation to abortion with voluntary assisted dying. So you may have expected that Victoria, whereas in the abortion context it allows conscientious objection but provides an obligation or requires health professionals to refer on, you would expect Victoria to have done the same thing with voluntary assisted dying, but it didn't. So in Victoria, for example, health professionals with a conscientious objection are allowed to refrain from participating in voluntary assisted dying, but there's no requirement to provide the patient with any kind of information that will help them to access that process elsewhere. And Tasmania, the same thing. Tasmania also in its abortion legislation allows for conscientious objection but includes an obligation to refer, but doesn't do so in the context of voluntary assisted dying. Other later states that have introduced voluntary assisted dying have begun to introduce some form of an obligation to refer. So that in some ways I guess is illustrative of what I was saying before when I mentioned that because this area is so new, we're bound to see kind of developments taking place incrementally which address some of the concerns which arise as we're seeing the legislation being implemented in practice. So, for example, Queensland essentially does have an obligation to refer in its legislation. Once I started talking to people and realised, what I realised was that the extent of conscientious objection to voluntary assisted dying is much higher than in relation to abortion. So for that reason, it seems like this was the failure to include an obligation to refer in voluntary assisted dying legislation was essentially a compromise to get the legislation through and to make sure that it was actually workable, because the reality is that there are a lot of health professionals who are not comfortable with voluntary assisted dying, much more so than abortion. And so that perhaps explains why the laws are different in the way that they are. The reasons for this difference, there may be lots of reasons, one of which is bound to be just that voluntary assisted dying is so much newer. Abortion's been around for so much longer that health professionals have had time to get comfortable with the concept, whereas with voluntary assisted dying it's a much newer concept, so it may take some time. And interestingly, a couple of the health professionals that I interviewed mentioned that the younger doctors seem more comfortable with it than the older doctors. So there could also be a generational aspect to it, where we start seeing that over time there is greater acceptance within the medical community, and therefore that may feed into changes to the law. Because as with everything in this area, there's a range of views. So some people will say, well, institutions are made up of the people who work in them, and if the people who work in an institution have, a certain set of values, then the institution should be able to represent those values as a form of conscientious objection. Other people will say conscientious objection is a right which belongs to the individual, that institutions do not have a conscience per se, and therefore there should be a prohibition on kind of wholesale institutional objections to what is something that an individual should be able to, something that has been allowed or given to an individual by law, given access by law. So this is really controversial. We've seen this debate happen over many years in the abortion context, because a lot of the Catholic hospitals, for example, still refuse to provide abortion services even though they receive government funding, and we're seeing the same concerns being expressed in relation to voluntary assisted dying, where we have certain mostly faith-based institutions who are the recipients of government funding but won't provide access to what is a lawful process that individuals are entitled to. So this issue of institutional conscientious objection it's very contentious, and it's one that we really need to grapple with, because when wholesale institutions are objecting to something like voluntary assisted dying, that has a very serious impact on the ability of people to access voluntary assisted dying. So if we're serious about saying that this is a legal right, then for it to be a real right in reality, people have to be able to access it. I would expect development in relation to various aspects of the legislation is what I would say. I think that as we see how the law is implemented in practice, we'll start seeing where the gaps are and where the problems are with the current law. And so we will see kind of incremental development in this space, as we've already seen with, states which have passed the legislation more recently, implementing provisions which are slightly different from, like, for example, Victoria's, which was introduced back in 2017. For example, New South Wales, which was the most recent state to legalise voluntary assisted dying, their legislation includes a provision saying that aged care facilities are required to provide access on their premises. So that's new. That doesn't exist in any of the other states' legislation, but is obviously an example of a realisation that has come about where people have realised that in other states, people in aged care are facing real difficulties accessing voluntary assisted dying.